Roy Moore in 2012. Mr. Moore, the former Chief Justice of the Alabama Supreme Court, has a judicial record that is sharply conservative on social issues but occasionally sympathetic to criminals. Cary Norton for The New York Times. Roy S. Moore, the cowboy hat-wearing Republican running for the Senate in Alabama, had been known for years as an attention-grabbing judge who blocked same marriages and insisted on displaying the Ten Commandments in his courthouse. But as women have accused Mr. Moore of UAL misconduct and assault in recent days, and as politicians in both parties have urged him to step aside, attention has focused on another part of his judicial record: his writings on rape and UAL abuse. Democrats and news outlets have noted, sometimes with scandalous subtext, that Mr. Moore dissented from the Alabama Supreme Court's majority in several instances to side with a person accused of UAL crimes. While that is true, the opinions are part of a distinct judicial record that is sharply conservative on social issues but occasionally sympathetic to convicted criminals. Mr. Moore has expressed concern over the years about mandatory life sentences for non-violent crimes, and once suggested that a death row inmate might not be getting a fair shake in the court system. He consistently was more interested in the arguments of the criminal defendants than many of his colleagues, said Matt Lemke, an appellate lawyer in Birmingham who has argued several cases in front of Mr. Moore. And I think that stemmed from a distrust of government power reflected in his judicial philosophy. Here is a closer look at Mr. Moore's 2 stints as Chief Justice on the state Supreme Court. He sided with the accused in cases more often than his colleagues did. During the Republican primary this year, Mr. Moore's opponent, Senator Luther Strange, released an advertisement condemning the Chief Justice's dissent in support of Eric L. Higdon, a teenager convicted of UAL assaulting a younger boy at a daycare center and sentenced to 23 years in prison. Unbelievably, Roy Moore was the only no vote in the 81 decision, the advertisement said, as images of children flashed on the screen and ominous played in the background. In that dissent, Mr. Moore put forth a legalistic argument that while Mr. Higdon was guilty of one form of sodomy, another sodomy law used to convict him was never meant to apply to abuse of children by other children. Mr. Moore wrote that sodomy is an abhorrent crime and should be strictly punished, but that I am concerned the court is stepping into the shoes of the legislature in this case. In recent days, several other dissents by Mr. Moore in cases have been highlighted, including at least 2 in which he questioned the application of Alabama's SHIELD law for UAL assault victims, which limits the ability of defendants to introduce evidence of the victim's past UAL behavior. Mr. Moore wrote in one case that he would have reviewed the conviction of a man for raping a 12-year-old girl in which the convict wanted to present evidence of the complaining witness' UAL history to show that the complaining witness had a motive to lie about having been raped. 2 other judges also dissented from the majority's decision not to hear the man's appeal. A New York Times review of 20 cases focused on UAL crimes and misconduct during Mr. Moore's tenure on the Alabama Supreme Court found that he sided with the accused 13 times, a higher rate than almost all of his colleagues. Many times, Mr. Moore was not ruling on the UAL conduct itself but rather a convict's request for the appeal to be heard. In at least 3 cases, the majority of the court sided with someone accused of UAL misconduct, but Mr. Moore dissented and sided with prosecutors. He showed empathy for defendants. When a man on death row missed a filing deadline with a lower court, and when most of the Alabama Supreme Court opted not to review his case, Mr. Moore was one of 2 justices who voted the other way and said some of the evidence used to convict him seemed deficient. In another instance, Mr. Moore wrote that a man's sentence of life imprisonment without the possibility of parole for a non-violent, drug-related crime reveals grave flaws in our statutory sentencing scheme, and in another case, Mr. Moore dissented and said a man's unpaid meal at a Waffle House should have led to a theft conviction, not a 35-year sentence for robbery. He called the case, which the majority voted not to review, a serious miscarriage of justice. 2 lawyers who worked for Mr. Moore at the Alabama Supreme Court said their boss had often empathized with defendants in criminal cases and feared they were sometimes wronged by the system. He was known as a judge who was more likely than his peers to side with a criminal defendant as civil plaintiff. He had no love for criminals, but he believed that every defendant was entitled to due process of law. One of the lawyers, Matthew Clark, said in an email, he saw many cases where the defendants, especially young black men, would be convicted solely on very weak circumstantial evidence, but he wasn't liberal by any stretch. Though Mr. Moore sometimes stood alone in criminal cases, he remained a conservative Chief Justice of a conservative court in a conservative state. In recent years, Mr. Moore joined in majorities that allowed the open carrying of firearms, restricted alcohol sales in some small towns, and upheld the use of tax credits for private school tuition in some instances. Douglas Inger Johnston, a justice on the Alabama Supreme Court during Mr. Moore's first stint there, said Mr. Moore arrived like a bull in a china shop and made administrative changes at the courthouse. His legal record was more nuanced, Mr. Johnston said. While I oppose Judge Moore's theocratic acts and positions, I appreciated his tendency to independent thinking in our judicial work on most of the civil cases before us, Mr. Johnston said in an email. My impression was that he genuinely wanted to apply correct law to accurately distilled facts, with care not to overlook facts or law favorable to the little guy, in most cases. Bobby Segal, an appellate lawyer, said in an email that Mr. Moore was courteous and pleasant when he appeared before him. But Mr. Segal also criticized Mr. Moore for religion-based antics, and said he was appalled by his disregard for the United States Supreme Court's ruling on same marriage. His remarks and positions have landed him in hot water. Since he was first elected Chief Justice in 2000, Mr. Moore has habitually made headlines and positioned himself on the vanguard of conservative culture wars. Over the years, he has questioned the fitness of adulterous parents, championed the role of religion in public life, and criticized gay people in stark terms, making himself a hero of the Christian right and a proud antagonist of the left. Homosexual conduct is, and has been, considered abhorrent, immoral, detestable, a crime against nature, and a violation of the laws of nature and of nature's God upon which this nation and our laws are predicated, Mr. Moore wrote in one case. Mr. Moore was removed as Chief Justice in 2003 when he refused a federal court order to move a Ten Commandments monument from the rotunda of the Alabama Judicial Building. After again being elected as Chief Justice in 2012, Mr. Moore last year was suspended for the rest of his term after he instructed probate judges to not issue licenses for same marriages. He does what he believes is right, both morally and legally, even when he has to pay a price, said Mr. Clark, who was working for Mr. Moore when he was suspended from office. He's a fighter. Kitty Bennett and Jack Begg contributed research. A version of this article appears in print on November 17, 2017, on page A16 of the New York edition with a headline in Sex Crimes and Other Cases, often siding with defendants.